Good afternoon, Your Excellency. My name is Bryan, and I'll be dealing with Naira's failure to ensure the rights of the Quispe sisters with regard to the forced slavery and gang rapes that occurred in the SMB in the 1990s, as well as the series of assaults on Maria Quispe in 2014. To this end, I will be making two submissions. First, Naira's domestic limitation period does not excuse their failure to investigate and punish the breaches of the Quispe sisters' human rights. Second, that Naira's failure to take any actions to investigate or prevent the series of brutal assaults by Jorge Perez is a breach of Maria Quispe's right to humane treatment. Turning to the first issue, Naira is obliged to investigate and punish the accused soldiers despite the lapse of the domestic limitation period. Naira cannot rely on its domestic statute of limitations to excuse its failure to investigate the forced slavery and gang rapes that occurred in 1992, and this rule is found in Article 27 of the Vienna Convention on Law of Treaties, which states that parties may not invoke provisions of its internal law as justification for its failure to perform a treaty. This position is consonant with this court's holding in the Bulacio decision in 2003 that any domestic legal obstacle that attempts to impede the investigation and punishment of those responsible for human rights violations are inadmissible. In that case, the court ordered the prosecution of policemen who violated a teenager's non-derogable right to humane treatment, even though their liability was extinguished under the Argentinian statute of limitations. Similarly, in Alban Conejo, this court similarly ordered the prosecution of a doctor whose malpractice led to the death of his patient and a violation of her right to life, despite the case being out of time under Ecuadorian law. In this case, considering the Quispe's rights were violated by agents of the state, even though their detention was not a violation of non-derogable ACHR rights, the obligation to investigate and prosecute the soldiers for all three violations should acquire a particular intensity that similarly requires the non-applicability of the domestic statute. The particular importance of prosecuting violations that were applied or tolerated by the state was recognized by this court in the massacres of El Mozete. We submit that in cases of state involvement, since the state apparatus effectively allowed and tolerated these violations, the only way to ensure the free and full exercise of ACHR rights is for the state to condemn these violations and restore confidence in the domestic judiciary and rule of law. In this case, it is a complete mockery in the accountability and condemnation for human rights violations that the ACHR stands for. The very state apparatus that allowed the Quispes and other indigenous women to be taken away from their families, cruelly detained and used repeatedly for labor and for sex, now stands before us and refuses to prosecute its own agents. Thus, it is submitted that the state should initiate an investigation into the forced slavery and gang rapes that occurred in the SMBs despite the lapse of the domestic time period.
So your case is that the limitation period should be ignored in this case, specifically because of the link to the government present on the facts. Is that correct?
Your Excellency, it is our position that the domestic limitation period should not apply in any case.
Okay.
However, in this case, specifically because of state involvement, it is particularly important for the statute of limitations to not apply.
Okay. And the proposition for that, or rather, that proposition is derived from the cases that you have mentioned, that statute of limitations generally doesn't apply to violations of human rights.
Yes, Your Excellency. Okay. So, turning to my second issue, Naira has failed to ensure Maria Quispe's right to humane treatment in two ways. First, it failed to investigate the first assault that occurred on the 20th of January 2014. And second, it failed to prevent the subsequent two assaults in May and August 2014.
Okay, sorry. Going back to the domestic limitation period, the domestic limitation period does not excuse them from the breach. So what is the breach here?
Your Excellency, the breaches here are that to their right to be free from slavery and as well as their right to be free from torture, as covered by my co-agent, Ms.
No, I
Burgess.
mean that one is too late already, right? So here, because those things have already happened, so here the problem is with the lack of prosecution, right?
Yes, Your Excellency.
Okay.
And the lack of investigation as well.
The lack of investigation and prosecution. Investigation, isn't that covered by the Truth Commission and all that?
Your Excellency, it's submitted that although the Truth Commission may serve as a form of investigation, it is insufficient in this situation, particularly because this court has emphasized multiple times that there's a clear distinction between historical truth and judicial truth. And in this case, we are more concerned with the judicial truth, which can only be obtained via court proceedings. This is seen in the case of Almanacid Arellano and Chile, as well as Zambrano Velez and Ecuador.
Okay, what is the difference? And why are we concerned with judicial truths in this case?
The difference specifically is that historical truth is okay, sorry. I need to think about this for a moment, Your Excellency. Okay, sorry. I'm not entirely sure what the difference is between the two. However, this court has just emphasized that court proceedings are particularly important in trying to determine the truth of what happened previously. I think it has to do with the process of the of how the truth is determined. So in a court, there are certain procedural safeguards that are involved that kind of maintain a standard that kind of help to determine what actually occurred. Whereas in a truth commission, it's more lax, and that the process is more.
Okay, anyway,
Yeah,
we're not going
sorry.
anywhere with that. So, if you have no answer to that, that's
Yeah, no answer
fine.
to that.
Okay, investigation and prosecution. So, Naira is a state, right? Naira breaches international obligations when it failed to prosecute. What is the source of this obligation?
The source of this obligation is Article 1.1 of the American Convention of Human Rights, which states that the state must ensure the free and full exercise of the rights guaranteed in the convention. And in the case of Velasquez Rodriguez, at paragraph 166, it states that the state must prevent, investigate, and punish any violation of the rights recognized by the convention, and if possible, attempt to restore the right violated and provide compensation.
Okay, prevent, investigate, and punish.
Yes, sir.
And so the issue here is that even after all of the relevant procedures have been carried out, it's not suggested that the individuals involved will be punished. Is that the issue?
Your Excellency, specifically with regard to the case of the SMB soldiers, the state did not take any investigation of its own accord, and necessarily that means that they were not able to punish or to prosecute because the investigation did not take place.
I'm sorry, which paragraph is that?
I think it's paragraph 33 of the facts. Sorry, I'm not particularly familiar with this set of facts yet.
Okay.
Do you have the facts again?
So the cases you have mentioned to me just now about the statute of limitations, they are in the same context, is it? Is the failure to prosecute due to the statute of limitations, and because of that, the relevant state breaches Article 1.1 obligation, is that correct?
Yes, Your Excellency. Specifically, in the case of Velasquez, is the failure to investigate, which is a similar submission to what we're making here.
Okay.
To correct myself previously, it's at paragraph 30, that second line, the acts of sexual violence were never reported by the victims or investigated by the state of their own initiative.
You probably need to find a better paragraph than that, because one, if they were never reported by the victims, I'm not sure how they are going to be investigated. And investigated by the state on its own initiative does not suggest that it has never been investigated or it never will be investigated. It just means that it won't be done on its own initiative. So this is a vague paragraph, but let's move on for now.
So turning to my second issue, the NIRA has failed to ensure the rights of Maria Quispe specifically with regard to the assaults by Jorge Perez. We made two submissions. The first is that there's a failure to investigate the assault that occurred on the 20th of January, and the second is a failure to prevent the subsequent two assaults on May and August 2014. So turning to the first submission, the obligation to investigate arises from the state's obligation to guarantee the right to humane treatment, which is Article 5, read with Article 1.1, which I mentioned previously. And once aware of a potential human rights violation, the obligation to investigate requires NIRA to initiate officially and without delay a serious, impartial, and effective investigation. And in order for such an investigation to be effective, it must be carried out with due diligence, which means the investigative authority must, within a reasonable time, take all necessary measures to try and obtain results. This obligation
just to check, are there any authorities that reads the articles this way, like reading Article 5 and 1, to say that there is a duty to investigate anytime there is a potential harm to an individual?
Yes, Your Excellency. This has been used in multiple cases, such as in the case of Cotton Field, in the case of Serrano Cruz sisters and El Salvador. So this obligation is one of means and not results, which means that it must be complied with diligently, but does not necessarily need to result in a punishment of the perpetrator, depending on whether or not the investigation yields any indication to the contrary. So on application to the facts, the Nairan Police's failure to initiate an official investigation into the violent disfigurement of Maria Quispe constitutes a clear violation of its obligation to investigate the first assault with due diligence. In Naira, official police reports are only filed when there is a medical certificate and the sole medical examiner in the area was on vacation. Thus, Maria was unable to undergo the necessary medical examination. Consequently, there are no official documents that establish that any investigation was done or that any information was collected by the Nairan police. Any arguments on the part of the state relying on the absence of the medical examiner must be dismissed because there are a host of other investigative measures which could have been taken. Some of these measures include interviewing the parties and the witnesses, recording the complaint in detail, and filling out an official police report on the complaint. State practice shows that other state parties to the American Convention on Human Rights have codified numerous potential investigative actions in their criminal procedure codes. For example, Brazil and Argentina have included interviewing the victims and witnesses as key actions to be taken when a report is made. The existence of these possible other investigative measures is buttressed by the fact that there are a number of breaches of human rights which do not result in physical injury. And for the state to be able to effectively investigate these violations, there must exist other investigative measures that are alternative to a medical examination.
I mean, the problem is that we don't know whether or not this requirement exists for cases involving physical harm, right? The fact that they require medical examination for this case doesn't mean that they also require medical examination for other cases of human rights violations which do not involve physical harm.
Your Excellency, I cited that as an example of other measures that can be taken in this case where there is physical harm and the medical examiner is away because he was on vacation. So even if we were to take Naira's position that a medical examination is paramount, it begs the question why Naira didn't conduct this medical examination at a later time when the medical examiner had come back. And they submitted that since there's a litany of alternative investigative measures which could have been taken by Naira in lieu of medical examination, that Naira is in breach of its duty to investigate the first assault with due diligence. Turning to the second issue, the second submission. Oh, sorry, Excellency.
Sorry, just to check on the facts, the individual who was injured, attempted to file a police report but was prevented from doing so because there was no medical examiner, is it?
Yes, Your Excellency. I refer you to paragraph 23 and 24 of the facts. The last line of second last line of 23 states that the only medical examiner was out of town and Maria Quispe could not undergo the respective medical exam. And it follows immediately that the police did not take urgent action because there was no medical certificate and there was no police report that was done.
Okay.
So turning to the second issue, my second submission, it is submitted that Naira has breached its obligation to protect Maria against violence by failing to take any form of protective measures to prevent further violations of her Article 5 right to bodily integrity. Naira's obligation to prevent the assault between private parties arises when three conditions are met. First, the state is aware of a situation of real and imminent danger. Second, this danger affects a specific individual. And third, there was a reasonable possibility of preventing or avoiding that danger. Given that the specific individual in danger is Maria Quispe, the fulfillment of the second condition is uncontentious. The first condition is met because after the first assault, Naira should have been aware of a situation of real and imminent danger because the first assault was pursuant to an extreme form of violence, disfigurement of a broken bottle, as well as the fact that there is a general context of domestic violence in Naira. From the time Maria reported the first assault, the state should have been aware that she faced a situation of real and imminent danger of future assault. Bearing in mind this general context, some statistics include 60% of the women in Naira being assaulted by their partners in 2016. And in 2017 alone, there were more than 85,000 instances where emergency services responded to instances of domestic abuse against women. Your Excellency, do you have a question?
Sorry, so what is the state expected to do?
The state could have taken a number of emergency protective measures. For example, they could have issued a restraining order against Jorge Perez. They could have prohibited him from approaching a domicile. They could have prohibited him from intimidating or harassing the victim or any of their family members.
As in through what? Court order?
Yeah, through a court order, Excellency.
But there's no evidence that Maria applied for them, right?
Your Excellency, it's our submission that when a police report is made, Article 25253 in Naira actually empowers the police to take these types of measures when necessary.
Yeah, but the problem with 25253 is that the medical report was not filed, and in any event is entirely irrelevant. If Law 25253 goes above and beyond what is required under the convention, surely the failure to comply with their own domestic law cannot be a breach of its international obligations, right?
Your Excellency, could you repeat the question?
My question is that there is no attempt to sort the court orders which you suggested should have been granted in this case. Then you told me that Law 25253 would have granted the police the power to provide the necessary protection. But Law 25253 is irrelevant for two reasons. The first reason is that the law itself is not satisfied because there was no medical certificate. The second reason why it's irrelevant is that it's domestic law. Even if it's domestic law is breached, that does not ipso facto mean that the police breached, or rather the state breached its international obligations, right?
Your Excellency, in this case, it's submitted that the state is in breach of its international obligations because there was an obligation for them to prevent the assaults, regardless of whether through the use of Law 25253 or otherwise.
Okay. So, do you have examples of breaches of the duty to protect? As I'm asking this because your suggested solution involves applying for a court order, or rather for a court to grant an order that was never sought. So what is the state expected to do in these kind of situations?
Your Excellency, if I'm not mistaken, Law 25253 does not require the victim to.
No, but anyway, Law 25253 is irrelevant because there is an obligation to protect, right, internationally. Whether Law 25253, whatever Law 25253 doesn't modify that obligation at all. What I'm asking is, obligation. What does obligation to protect entail? Does it entail the state issuing court orders, which you have suggested, when the potential victim in question didn't even apply for it? Is that the extent of action that is required?
Your Excellency, the standard of prevention is the adoption of effective measures that would have reduced the risk factors for the potential victim. This was set out in the case of Cotton Field at paragraph 279.
Okay.
So it is our submission that the state could have used Law 25253, but in any event, even if they didn't use Law 25253, there is this international obligation for them to protect, which I suppose they could have fulfilled in any other way, but they have failed to do so.
Yeah, effective measures, right?
Yes, Your Excellency.
So like what?
As I mentioned previously.
Okay, so the things that you mentioned previously are court orders, correct? So, right, I can understand you saying that the threshold of effective measures have not been met if Maria applied for those court orders, didn't get them, and then got subsequently abused. But here, there was no attempt to apply, or at least there's no evidence of that. So are you saying that whether or not she applied is irrelevant, because those orders should have been issued anyway, and that is the minimum standard of effective protection? Or are you saying something else?
Your Excellency, it's our position that when the three conditions are met to such that the obligation to prevent arises, then the state should take any form of effective measures, regardless of whether or not Maria had applied for them.
Okay.
And also, Your Excellency, I see that I've run out of time. And actually, through the questioning, I already covered most of my substantive points. If I may be of no further assistance to the court.
Okay, sure.
I think you overpitched your statute of limitations point there.
Really?
Because I don't think you to say a statute of limitations never applies.
You can
Sorry.
Okay.